introduction, and thank you, all of you, for being here, and to the law school and the co-sponsors for organizing this terrific symposium. So as mentioned, I'm going to talk about trends in state medical marijuana policies. A few of the issues that I'll touch on, I know that some of the speakers and panels later in the day will get into it more in depth, and I'll just provide a cursory overview on some of those things. So before we look at the state medical marijuana laws, it's worth taking a quick look at federal policy, because of course there would be no need for states to enact medical marijuana laws if a patient could have their doctor prescribe medical marijuana and if they could go to a pharmacy and fill that prescription. However, under federal law, marijuana in 1970 was classified as a Schedule I controlled substance. That means that it has high potential for abuse and no currently accepted medical use and treatment, even though more than 500,000 Americans are now recommended medical marijuana in the various states. So as I said, that means that marijuana cannot be legally prescribed. Distribution of marijuana is strictly illegal under federal law, with one exception, which is for research. Over the years, there have been a number of petitions that have been filed asking the DEA and the federal government to reschedule marijuana into a category that would allow for it to be prescribed eventually, such as Schedule II or lower. The first petition was filed in 1972, and the DEA took its time. In 1988, they finally ruled on it, and the judge had a recommended ruling which the higher-ups, the political appointees, did not need to follow. He's found, his name was Francis Youngman. He was the chief administrative law judge for the DEA, and he found it would be unreasonable, arbitrary, and capricious to fail to reschedule marijuana. He had heard from patients and physicians. As we know, that was rejected by the DEA's, the political appointee at the head of the DEA, and the courts upheld them not rescheduling marijuana. Over the years, there have been other attempts as well to try to petition the DEA to reschedule marijuana. The most recent one was rejected after being sat on for about 9 years, just this past July. So because the only exception under federal law was for research, states' initial attempts to allow seriously ill patients to access medical marijuana sought to cooperate with the federal government and to use that narrow exception to provide access to patients. When we talk about the medical marijuana laws that are in effect, we don't normally talk about these states, but 25 states passed therapeutic research laws between 1978 and 1995. Those laws were not actually designed for research. Their purpose was access. They weren't placebo-controlled studies with rigorous clinical data. I believe some of their data wasn't even published until a decade later when people went through to look at what the findings had been. Only 7 of them were ever operational. Most of them never got off the ground, and those ones also stopped being operational by sometime in the 1980s. Since that time, federal policies on allowing medical marijuana research have gotten more restrictive. In 1999, the Health and Human Services, Federal Health and Human Services, said that they didn't think it would be appropriate to have long-term ongoing clinical studies. And since that time, even these rigorous placebo-controlled short-term studies that were not designed to actually provide patients with access, but to provide research, in some cases were denied federal marijuana. Under federal law, there is one and only one source of marijuana, and that's marijuana grown in the University of Mississippi for NIDA, the federal government. So there were actually a number of FDA-approved studies by people seeking to do the research that would be necessary to reschedule marijuana or to make it a prescription drug, where NIDA refused to provide marijuana to the FDA-approved study. Most recently, that was a PTSD study just this summer. So because the initial attempts to allow medical marijuana, where they depended on federal cooperation and explicit approval, were not effective, states looked for another way to allow access to medical marijuana. In 1996, voters in 2 states, Arizona and California, voted on medical marijuana initiatives that had been put on the ballot. Arizona's was similar to another kind of medical marijuana law that we also don't hear about much, that allowed marijuana to be prescribed, which of course cannot be done under federal law. California's was different. They sought to only remove the state's own criminal penalties from the use and possession of marijuana. They also allowed caregivers, because a lot of the patients would be too ill to grow their own marijuana, to grow marijuana for the patients. The Clinton administration was not pleased. They told doctors that if they recommended medical marijuana, their license to prescribe drugs could be pulled. So an AIDS doctor went to federal court and said he had the First Amendment right to recommend the medical use of marijuana. Ultimately, the Ninth Circuit Court of Appeals unanimously agreed, and now all of the medical marijuana laws rely on a doctor recommending or certifying or something similar medical marijuana. So they all rely on a doctor's protected First Amendment speech about what their medical opinion is about whether or not a patient would benefit from medical marijuana. The court also found that marijuana could not, of course, because of federal law, be prescribed, so Arizona's and other laws were ineffective and did not provide relief. After California, a number of other states passed similar laws. We'll get into some of the differences between the laws later on, but all of them involved home cultivation by individual patients, individual caregivers, and that was the means of access. Some of the laws allowed a caregiver to serve only one patient, others allowed 3, and some of them allowed unlimited patients to be served by an individual caregiver. This ended up resulting in essentially unregulated dispensaries down the road in some states. There's a reason that most people don't grow their own food. You know, it's a lot easier to go to the store and buy something than to plant a seed and wait months and months and months and months that your green thumb works out for you. And especially when somebody's life depends on it, it's not the best system for some patients. Some patients do like home cultivation. People with long-term illnesses like to be able to grow their own medicine in many cases. They find it therapeutic and much cheaper. But for a lot of people, having a dispensary and some kind of regulated, controlled, central place of access is the best means of access for them. So California became the first state to explicitly allow larger scale distribution in 2003. This was not when the dispensaries began in California, though. There were actually dispensaries even before Prop 215, the 1998 initiative, passed. As early as 1992, San Francisco, the city gave its blessing to what was known as a Cannabis buyers cooperative, where AIDS patients were served with medical marijuana. So this law was very vague. It just said that the collective and cooperative cultivation of marijuana people wouldn't be subject to criminal penalties on that basis. So some cities then went and they created very good regulatory structures for dispensaries. Other ones tried to ban dispensaries, and other ones did nothing and ended up with a lot of unregulated dispensaries that caused some of the headlines about there being more dispensaries than Starbucks at one point in LA and things like that. And you'll hear more about dispensaries in more detail later on. So in 2007, the first state decided to license producers and allow regulated, state-licensed, larger scale cultivation. And this law, part of the law was immediately implemented to allow home cultivation, like other states had, and protection from arrest. However, the part allowing for the larger scale cultivation was not implemented until President Obama was in office. There was concern that perhaps state workers could be at risk. The Attorney General issued an opinion. Of course, there were raids in a lot of these California dispensaries that were going on, so that was surely a concern as well. When he was running for office as a candidate, President Obama said that he would not use federal resources to circumvent states' medical marijuana laws. And over the next several months, when he was first in office, various similar statements came out of the White House. Attorney General Holder was actually specifically asked about dispensaries in New Mexico before they opened shop. And as you can see, he said that for those organizations that are doing so sanctioned by state law and that do it in a way that's consistent with state law, that would not be a focus of federal resources. So New Mexico went ahead, at first licensed a few producers, and now they have 23. None of them have ever been raided by the federal government. In October of 2009, the federal government issued a formal memo from the Attorney General's office, the Deputy Attorney General, that said that when agents were pursuing priorities to disrupt drug trafficking, they should not focus on individuals in clear and unambiguous compliance with state laws, such as patients or caregivers. And it listed the types of illegal drug trafficking activity that could be of potential federal interest. And those were things like violence, criminal enterprises, and sales to minors. It did note that the memo did not provide any kind of defense that could be raised in court, and that's known as the Ogden memo after the author of the memo, David Ogden. So with a shift in federal policy, states sought to set up a regulatory system so that people could actually be in clear and unambiguous compliance with the law, since in California, there's a lot of litigation about what exactly was allowed, and also to address community concerns and provide patients with a means of safe access. In the next few years, 4 additional states, DC, which isn't a state, passed new laws that included regulated dispensaries, and then 3 states with existing laws passed laws to add dispensaries onto their state laws. And in the case of Colorado, there were already numerous dispensaries. This just set up a regulatory structure. Then last year, after all the states had moved forward, there hadn't been any raids in those states with very clear regulated laws like like Colorado, New Mexico, and Maine. We saw a dramatic shift in the statements that were coming out of federal prosecutors and the federal government. The governor of Washington was considering a law that would have set up another regulatory structure for dispensaries that essentially already existed in the state but were in a legal gray area. And she asked the U.S. Attorney for their opinion on this law, or bill at the time. And the U.S. Attorney said that essentially dispensaries could be targeted, and also said that the state workers were not immune from liability under the Controlled Substances Act. The governor was afraid that perhaps state workers could be prosecuted, and she vetoed all of the dispensary parts of the bill. After that, other U.S. attorneys sent similar letters when they were requested from other states that indicated that dispensaries could be prosecuted. Most of them did not mention state workers. So last June, the new Deputy Attorney General issued a new memo, and that memo was what I believe was a dramatic retreat from the Ogden memo. It claimed that they never intended to protect larger scale dispensaries, that they only meant to protect patients and caregivers. And it left it up to federal prosecutors with their own prosecutorial discretion to decide whether or not to target dispensaries. So since that time, we've seen a lot of confusion in the states. They were moving towards a much cleaner program. You weren't hearing complaints about dispensaries in the states where you had clear regulations, the communities were happy, patients were well served, and now this has kind of thrown the issue into turmoil. So Delaware's governor was implementing a law that just passed last year. He got a very similar letter to the one that came out in Washington and put the medical marijuana dispensary program on hold. Some other states temporarily put their laws on hold and ended up restarting the programs, and now we see a number of states that are expected to implement in the next few months. Still, we haven't seen any raids in New Mexico, Maine, or Colorado, although there have been some threatening letters to dispensaries that were close to schools in Colorado. But we've also seen a dramatic shift in the last year or so in federal statements on the issue. And we've seen increased raids in those states with laws that are not as clear. There have been a number of raids in Montana, California, and Washington State, and people who were trying very hard to be above board, some of them which invited legislators in, and local police officers were suddenly raided in Montana and prosecuted. Now stepping back and looking at some of the other ways that trends we've seen in state medical marijuana laws. In California, that was the first law. It was about 1/3 of a page. It was very, very vague, and it said that physicians could recommend medical marijuana for any condition. This is the only law that allows full protection for any medical condition. So insomnia, anxiety, mild pain, those type of conditions could all qualify in California. The future laws listed specific symptoms or specific medical diseases or conditions that people would have to qualify. The grid that you have has a list of what the conditions are state by state. And as you see, pain, nausea, wasting, seizures, muscle spasms, glaucoma, AIDS, and cancer are in either all or almost all of the laws. And then more recent laws have also included Crohn's disease, Lou Gehrig's disease, Alzheimer's, and hepatitis C. And 2 of the more recent laws, Delaware and New Mexico, include post-traumatic stress disorder. I believe all of those newer conditions are ones that a lot of the states allow the health department to be petitioned and asked to add additional conditions to the state medical marijuana law. And most or all of those conditions are ones that a state first added after a medical review panel or the health department decided there was enough medical evidence to add the condition. That was the case with post-traumatic stress disorder that was added at the recommendation of a number of doctors that were on a panel in New Mexico, and then the health department added it to that program. So another way that the state laws differ is how much marijuana is allowed. California, again, was very vague. It was the first law that said marijuana could be allowed in an amount for personal use. So that caused problems in some cases, because some law enforcement officers might interpret, a very small quantity of marijuana as not an amount for personal use, and then the person would have to go to court and litigate it. In other states, there was a specific amount of marijuana, and in most cases, that amount was an amount that a person could not be arrested if they had. Some of the states included a defense that could be raised in court if an additional amount of marijuana was needed. And as you can see, it varies very widely. The lowest amount of usable marijuana is 1 ounce, and the highest is 24 ounces. It's mostly been a political decision. You know, opponents of medical marijuana point to the thousands of joints that they think would be allowed if it would be a large amount of marijuana, and then because of concern about that, smaller amounts are allowed in some cases. But the state with the highest limit is actually Washington State, which initially had a law that said a patient could possess up to a 60-day supply of marijuana. It was undefined. Later on, the state legislature asked the health department to conduct hearings and find out what a 60-day supply was. So this was, I believe, the only state that had the state health department tasked with figuring out how much marijuana should be allowed. And they talked to patients, law enforcement experts, and they came up with 24 ounces, which was the highest limit, which means that the other limits are probably too low. And they also came up with 15 total plants, which could be all mature or some mature, some immature. Now, another trend that we've seen in the more recent medical marijuana laws is they've included more regulations. As you heard, a lot of the more recent laws included actual regulated dispensaries, but in addition to the regulation on organized access, they've also included other kinds of restrictions. So, for example, the more recent laws require that if marijuana is cultivated by a patient or a caregiver, that it be in an enclosed, locked facility, which would make it less likely that it could be stolen or that other things like that could happen. In addition, newer laws include a stricter relationship that a patient and a doctor have to have. Most of the laws, other than California's, say that a doctor and patient have to have a bona fide doctor-patient relationship. So the idea was that the medical boards would be able to define that just as they would regulate doctors who would, you know, if they were to prescribe marijuana or prescribe a joint to somebody who they didn't have a bona fide doctor-patient relationship with. Some of the medical boards in Montana, for example, there was a problem where there were what's called cannabis caravans, that a doctor would see a patient for a very short amount of time in a non-medical setting and issue a huge amount of recommendations. Eventually, the medical board did what was intended, and they came up with regulations and said what would consist of a bona fide doctor-patient relationship, but it was a while after the fact. So some of the newer laws actually spell out what kind of relationship is required instead of waiting for the health department or the medical board to do so at a later time. Another development is most of the states, all of the states except Washington, have at least optional registry identification cards, and in most of the cases they're mandatory. For a lot of patients, this is better for both the patient and law enforcement because the registry identification card is something that law enforcement could very quickly and easily verify. So the patient sends in their doctor's recommendation to the health department verifies that the doctor is real, that they really recommended to the patient, and then they give them an ID card so that the law enforcement agent can call the health department, verify that the ID card is in fact valid, and then let the person be on their way if they're in compliance with the law. Another development, which I think some of these are aspects that a later panel will discuss, is that newer laws include a lot more patient protections. In some of the states with the earlier laws, patients specified that a patient couldn't be arrested or they couldn't be convicted for the medical use of marijuana, but they didn't specify that a patient couldn't be discriminated against in other ways that would be protected if they used a prescription drug under the ADA or other state law. So, for example, patients in California, one was given a pre-employment drug test, and there was no allegation that he was ever impaired at work, but he used marijuana at night at home and was denied employment. So some of the more recent laws include some kind of employment protections which vary by state. In addition, in some cases, people have been denied child custody, not because of any actual conduct related to marijuana that endangers the child, but merely because they use marijuana for medical purpose. So some of the newer laws include protection for that as well. In a very sad case in Washington State, a musician was waiting on a list to get a liver transplant, and he was told he couldn't use marijuana for 6 months before the transplant. It wasn't because the marijuana itself was a danger if he used it within 6 months, but again, because marijuana is illegal under federal law, and he did not have 6 months to live, so he passed away waiting for a transplant that he was denied because he was a medical marijuana patient. So these are all issues that some of the more recent state laws have actually clearly spelled out would be protected from discrimination. So to recap, here's a map that shows all of the states that have some type of medical marijuana law. The states in black have protections from patients from being convicted